Hello and welcome to the Law Lab YouTube channel. Here we dissect and unpack everything legal. My name is Asiedu-Antwi, and today we are looking at law of contracts. Specifically, we are looking at mistake, and more specifically, today I'm looking at Contract Inter Praesentes. Contract Inter Praesentes. In the previous video, I started by looking at the types or kinds of mistake. I've treated mutual mistake and I'm on unilateral mistake as to the identity of the contracting party. And I mentioned to you that in order to prove or to make the court believe in the argument you're advancing on a unilateral mistake as to the identity of the contracting party, you must prove three elements. One, that you intended to contract with a different person and the rogue actually knew that you intended to contract with a different person, not he or she, the rogue, but ended up contracting with the rogue. Two, you must prove that you considered the identity of the person you were contracting with as a matter of crucial importance. And three, you even made steps to confirm or affirm the identity of the contracting party. That is leading us to today's topic of Contract Inter Praesentes, and it is a presumption in law. And the presumption simply means that where you contract face to face with somebody or another person, it is difficult to prove to the court that you did not intend to contract with that person but a different person. Maybe let me put it in a different context. Contract Inter Praesentes is a presumption in law that, or the law presumes that where you contract with a person or another person in face to face, there is that presumption that it is that person you intended to contract with, not a different person. Let me give an example. Say, Aaron, I contract with my sister Jacqueline Opoku. The law presumes that maybe I wanted to contract with Risa and not Jacqueline Opoku. The law will presume that since I contracted with Jacqueline Opoku, then there is that presumption that yes, since it was a face-to-face contract, then that presumption will hold. However, there are certain circumstances the presumption is being rebutted. But let's look at how the presumption works in these three cases. The first case I'm going to rely on is the case of Philip versus Brooks. Philip versus Brooks. And in Philip versus Brooks, the rogue called North represented himself as somebody called Sir George Bullough, a credible man, and the plaintiff actually confirmed the address and gave the goods to the rogue North. The rogue ended up selling it to the defendant. Now the plaintiff brought an action against the defendant by saying that we intended to contract with Sir George Bullough, not North, the rogue. Now listen to the court. The court held that, well, the plaintiff intended to contract with the person who they identified by sight and hearing. Thus, the contract was not void, but voidable on grounds of misrepresentation. And as such, since the plaintiff had not avoided the title of the rogue as of the time the rogue was transacting with the defendant, then the contract is not void. So the law upheld, or the case upheld, the principle of Contract Inter Praesentes, that the plaintiff intended to contract with the rogue, or the one they had in sight, which was the rogue. Now let's contrast this case with the case of Ingram versus Little. Ingram versus Little. Now, the rogue was called Hutchinson, and he entered the residence of the plaintiff and represented or gave him a check that he's purchasing a car at a certain price. And he said, well, I'm Hutchinson. And the court said, the plaintiff said, no, we are not going to contract with you on this check. And he went ahead to say that, no, I am P.J.M. Hutchinson, who was a credible man. The plaintiff now went ahead to confirm through a telephone directory to actually affirm that whether it was P.J.M. Hutchinson. Well, the address given to the plaintiff by the rogue was that of P.J.M. Hutchinson. They went ahead to contract with the rogue, and later the rogue sold to the defendant. The court said, well, the presumption will be rebutted and the contract cannot be affirmed, or the contract should be void, in the sense that before, in fact, when the rogue presented the check to the plaintiff, there was no contract because the plaintiff rejected the check, and up until the rogue actually mentioned that he was PGM Hutchinson, and the plaintiff confirmed through the telephone directory. So the plaintiff, in a way, has satisfied the three elements I mentioned early on that you must actually go through in order to prove that indeed there is a unilateral mistake as to the identity of a contracting party. However, the principle of contract inter praesentes was not upheld in the case of Lewis versus Avery. And Lewis versus Avery, this is what happened. Now, in Lewis versus Avery, the rogue, who was posing as one Richard Green, a film actor, called on the plaintiff to buy his car. Now, the plaintiff accepted the offer and was given a check. And now the plaintiff refused the check. Listen, here the plaintiff only refused the check. And then the rogue shows a stamped pass of a Pinewood Studios, and the plaintiff allowed that. Well, if I've seen this stamp pass of the Pinewood Studio, then he went ahead to contract with the rogue. The court is saying that the principle of the presumption of face-to-face was not rebuttable, in the sense that the person was in front of you, he only showed you a stamp pass of a Pinewood Studio, and you accepted. You did not take any extra caution to actually verify the identity of the rogue. Unlike Ingram versus Little, where he said, okay, I am PGM Hutchinson, and he said, okay, then they went ahead to confirm the identity of PGM Hutchinson through a telephone directory. So in these three cases, in Phillips versus Brooke, the principle of contract inter praesentes was upheld. In Ingram versus Little, the principle was not upheld. However, in Lewis versus Avery, the principle was upheld. Now, let's look at how the principle can be rebutted. It can be rebutted in about one or two ways. One, the first one is that where a rogue is contracting with a person, and the rogue says that he's acting as an agent of a principal, in that particular instance, that principle will not work, because you are not contracting with a principal, and you have no means to even actually confirm the authority of the agent. So he says, where the rogue dishonestly claims that he is acting as an agent for another person, a supposed principal, the presumption which applies in a contract inter praesentes will be deemed to be rebutted. Let us look at the case of Hardman versus Booth. Hardman versus Booth. In Hardman versus Booth, it was clearly stated that the plaintiff visited Gandel and Sons and met the rogue, who identified himself as Edward Gandel. And the rogue convinced the plaintiff that he has authority of which he had not. He had the authority of which he had not, and ordered the plaintiff to supply the goods. And the rogue intercepted the goods and sold it to another person. The court said that the principle will not apply since he has no authority of the supposed principal. We may also consider the case of Shogun Finance Limited versus Hudson. Shogun Finance Limited versus Hudson, where the rogue claims that he is Mr. Patel and wants to buy a Mitsubishi Shogun on hire purchase. Now, he produced Patel's driving license, and the contract was signed between the rogue and the finance company. The rogue later sold the goods the car, the Mitsubishi Shogun car, to a third party, that is the defendant. Indeed, the court is saying that the defendant actually acquired a valid title, and that the principle of contract inter praesentes will not apply. Today, we've looked at contract inter praesentes, and I began my lesson by recounting the three elements you must prove when you are actually arguing or positing for a unilateral mistake as to the identity of a contracting party. One, you must be able to prove to the court that you intended to deal with some other person other than the rogue, and the rogue also knew that you do not intend to deal with him but another person. Two, that at the time of entering into the contract, you considered the identity of the other contracting party with a matter of crucial importance. And the third one is that you took reasonable steps. Now, the principle of Contract Inter Praesentes simply means that when you contract with someone face to face, it is difficult for you to say that you did not intend to contract with that person, and that the law will presume that indeed you intended to contract with the person in sight. You may consider the case of Phillips versus Brooks. We may consider the case of Ingram and Little, and we may consider the case of Lewis and Avery. In the first and third, the court said that the principle should hold, but in Ingram versus Little, that principle did not hold, in the sense that in Ingram versus Little, after the gentleman identified himself as PGM Hutchinson, the plaintiff took reasonable steps to confirm through a telephone directory. The other two cases, there were no reasonable steps taken by the plaintiff, and so the court said that the principle of Contract Inter Praesentes should hold. In our next video, we considered again the rebuttal position, where I mentioned the agent case, which is the Hardman versus Booth, and also the case of Shogun Finance Limited versus Hudson. Shogun Finance Limited versus Hudson. In our next video, we will be looking at the last kind of mistake, that is common mistake, and I'll take my time to take you through all the three types of common mistake. Thank you very much for watching. This has been the Law Lab.